case was, the Taricani matter grew out of a case that was an investigation of alleged corruption in the city of Providence on the part of the administration. It was a fairly wide-ranging case. And it began with the indictment of some lower-level, relatively lower-level city officials who were accused of basically selling favors and influence. And these individuals were indicted. The FBI had made video undercover tapes which purported to show the director of administration actually taking a cash bribe from an individual. Some of the individuals were indicted, and the grand jury was in the process of continuing its investigation because there were suggestions that this reached all the way up to the mayor, and the mayor may be implicated. The surveillance tapes were provided to the defense counsel during the course of discovery so that they would be able to adequately prepare defenses for these individuals. The grand jury investigation was still continuing, and the judge who had the case at the time, which was not me, entered a protective order with the consent of all of the parties, which provided basically that the tapes could be furnished to the defense counsel but were not to be disclosed to anyone else, partly because this particular tape was dynamite. It looked very incriminating for the director of administration, and as it turned out, it was very incriminating. And it was going to be a key bit of evidence at the trial. Well, at that point, shortly thereafter, this tape was aired on one of the local television stations just before the trial of the lower-level officials was to take place. And Mr. Taricani was the reporter who obtained the tape and caused it to be aired. And as I said, the grand jury investigation was still proceeding. So I appointed a special prosecutor to look into who leaked the tape to Mr. Taricani, because among other things, it was appeared to be a direct violation of the protective order that had previously been entered. It obviously jeopardized the rights of the defendants to a fair trial, because if that tape were aired, it had the potential to poison the prospective jury pool. The special prosecutor, I thought, acted very responsibly in the case, and he interviewed and/or deposed everyone who apparently had access to the tapes, all of the defense attorneys and anyone else who conceivably could have been the source of this leak. And he did so in an attempt to not have to ask Mr. Taricani to disclose his source if he could avoid it. Well, needless to say, no one admitted to being the source of the leak, so he was left with no alternative but to ask for permission to depose Mr. Taricani, which he did, and Mr. Taricani refused to answer the question. He then brought a motion to compel him to answer, which I heard. We had an evidentiary hearing. I determined that there was no privilege applicable there, and there was no applying the balancing test, that he would have to disclose the source because this was a criminal act that threatened the integrity of the trial. And he declined and took an appeal to the First Circuit, which was his right to do.